Welcome to California in Focus. I'm your host, Keegan Kernodle, and joining me today is the Center Square's California reporter, Kenneth Schrutt. So Kenneth, tell me more about these loopholes in California's mental health diversion program that lets criminals not go to jail.
Right. So in California, we have something called a mental health diversion program that lets mentally ill individuals charged with domestic violence, human trafficking, or assault of a child under 8 that results in a child's death. So people who have killed children, they're allowed to seek mental health treatment instead of facing criminal charges and prison time. So these are some loopholes within the existing law that are in effect today.
And is there any plan to do anything about this?
There was a plan. That plan was Assembly Bill 433, the bipartisan bill that was authored by Assemblywoman Maggie Krell, who represents Sacramento. It failed in the Assembly Public Safety Committee when the only people who voted for it were 2 Republicans. So didn't get out of committee. It would have been a very narrow bill that would have just ended the loopholes for, again, just domestic violence, human trafficking, or assault of a child under 8 that results in the child's death. Would have just ended the mental health diversion loophole for those specific cases. But again, that failed the Public Safety Committee.
Now, these sound like some pretty wild loopholes, you know. Is this actually happening? Is there any examples of this happening?
Yes. So this is not a compulsory program. It's discretionary. So judge, prosecutors, they can decide whether or not they want to grant someone diversion. There are some cases where it's been granted that do cause significant concern. Sacramento County Sheriff Jim Cooper, he was a former Democratic assemblyman, now sheriff, testified in support of the bill. He shared a real world situation where a diversion resulted in no criminal record and no prison time for a man who was blackout drunk when he beat his 1-year-old to death. This man, Mark, he was taking care of his 1-year-old daughter, and he got blackout drunk. He drank a pint of vodka and many beers, and she died of the injuries from her father's beating. Mark claimed that he was too drunk to remember what he did, so prosecutors couldn't prove his intent to kill. As a result, he only faced felony child abuse charges instead of murder charges. So that made him eligible for a mental health diversion instead of prison. As a result, what Mark had to do was take, quote, a few virtual classes, and he had no criminal record. Or at least that's what Cooper said. I really do want to read this quote from Cooper, though. It says, "The judge congratulated him and the courtroom clapped for him. Today, Mark has no criminal record. Mark is considered the victim for not remembering how he brutally killed his baby girl." So this is just one real world example of where this rule seems to have not done what it's supposed to do. Or perhaps this is what it's supposed to do. I'm not sure.
I see. And this bill going against it seems like it would be pretty straightforward, you know, something that people would want to support.
Yeah. And the Assemblywoman who wrote it, Maggie Krell, even in her statement of support, she's not even advocating for ending the mental health diversion program. Because like if there is a very mentally unstable homeless person who isn't in control of themselves at all and is for example like stealing things or committing some like minor crimes, is it worth spending the money that our state does on prison for that person, or should they get mental health treatment? I think there's a very good case that they should just be put into a facility to get treated, and maybe they can't leave. Maybe, I don't know. But there are reasons that this program exists. But she says, As applied to offenders who are dangerous and seek to continue to abuse their victims, this law creates a major public safety gap. While there are certain cases where pretrial mental health diversion would be an appropriate alternative to criminal sentencing, this law fails to provide justice for victims who have been trafficked, abuses children, and individuals who have sustained great bodily injury. There was a Assembly Public Safety Committee analysis of this bill. It shared findings of a study that said that more than 30% of the state's prison and 23% of its jail populations have a mental illness. The report also said that promoting treatment over incarceration has shown positive results in reducing recidivism. Notably, opposition to this bill came from the American Civil Liberties Union and Smart Justice California. Smart Justice California is a project of the George Soros-funded Tides Advocacy. What they said in opposition to the bill was, AB 443 seeks to limit the discretion of judges to apply mental health diversion to candidates that are currently eligible. Current law never requires courts to grant diversion. It merely gives the court the ability, where appropriate, to use its informed discretion to divert mentally disordered people out of the criminal system and into the mental health treatment system. So after the bill failed, Jim Cooper, he announced that he's hosting an event in Sacramento, actually today, pretty much right now, to discuss the state's mental health diversion program and impact on the state.
Well, thank you very much, Kenneth. It's very interesting to see where this goes, especially with Cooper on that side and many others on the other side. But we'll be keeping up with this, and listeners can follow along at thecentersquare.com. Thank you for joining California in Focus.